SJC-12673, Commonwealth v. Don Earl Johnson.
Mr. Gauthier, good morning.
Good morning, Mr. Chief Justice, Associate Justices. My name is Edward Gauthier, and I'm appearing today on behalf of the defendant appellant Don Earl Johnson. May it please the court. One of the most fundamental canons of statutory interpretation is that every word of a statute must be given some meaning, even in cases like this where the meaning of a word or a phrase is not clearly spelled out by the legislature. In this case, we're dealing with a very short phrase, have had their liberty otherwise restrained. We are arguing that individuals should be able to take advantage of the statute allowing for DNA testing in cases like this if they have been required to register as a sex offender as a direct consequence of their conviction. And in this case, Mr. Johnson actually was convicted prior to the enactment of the Sex Offender Registry Notification Act. So he had no opportunity at the time of his plea to challenge his subsequent registration.
Your argument is it applies to someone who is a level 1
A level 1?
sex offender.
There's nothing in the evidence to suggest that Mr. Johnson is a level 1 sex offender.
All right, I'll borrow a phrase. Try my question. All right, would it apply to someone who's a level 1?
A level 1 sex offender's liberty is restrained slightly as compared to a level 2 or a level 3 sex offender. But in our position is every individual who's trying to take advantage of the statute should have their case treated on a case-by-case basis.
Your person's unique because they're sitting in a jail in Florida, correct?
Mr. Johnson actually, due to the hurricane in Florida, was transferred to a federal prison in Mississippi, but
Oh, he went from Mississippi to Florida, now back to Mississippi.
now back to Mississippi.
Okay, so your person is in jail in Mississippi
in a
right now.
federal prison as a result of failure.
Right. But my question was, apart from your client, does it apply to someone who's a level 1?
If I had a level 1 client, I would certainly make the argument that it does. However, obviously the restraint of liberty of a level 1 is far less
Does
than.
it apply to someone who's held in Bridgewater as a sexually dangerous person?
I would argue that absolutely it does. Our argument would be that any level 2 or level 3 sex offender, anybody civilly committed, or I would argue also anybody subject to deportation as a
Now
result.
you're taking my level 1 out of it?
I wouldn't want to do that to another person who may come along down the line, but I would acknowledge that a level 1 sex offender does not face nearly the restraints on liberty that a level 2, a 3, a civilly committed person, or a person subject to deportation. Those are very high levels of restraint of liberty. But however, the statute doesn't say have had their liberty severely restrained. It just says has had their liberty restrained.
So what's his level?
Mr. Johnson's level's not in the record.
So we don't know he's a 1 or not?
We don't know. He's not a resident of Massachusetts, so his level is,
Well, his registration requirement's over.
he is still,
His state registration requirement is over.
pursuant to the statute as of 2015, his Massachusetts state obligations have ended. However, he is a resident of Mississippi.
So you're saying, so it's subject to a person subject to deportation?
I would argue a person subject to deportation.
So that's not a person who's being held by ICE, a person just subject to deportation?
A deportation, or anybody convicted of a sex offense is likely going to be deported if they're not here, if they don't have legal residence.
So you would open this up as well to people who else is there? So anyone who is not here, any undocumented person with a sex offense would be covered in this case?
If they're subject to removal proceedings, I would argue yes.
But we don't need to decide that here.
Absolutely not. This
So
case
I
only
guess-
needs to be decided on the facts of the
Right,
case.
but it appears as if one of the issues which this case recognizes is that what I hear you saying, or at least what I take from what you're saying, is that we can't use levels because levels is a Massachusetts thing, and we don't even know whether Mississippi has levels. For all we know, you could just be viewed as a sex offender, and they may not even adopt the same Massachusetts view of doing different levels, or they could define levels differently.
But it's a federal registration, it's not a state. He's in prison, federal prison for failure
Yes.
to register as a federal sex offender, not this. Actually, he was charged in Mississippi, but
Yes.
in,
The federal failure to register charge would have likely have been crossing state lines without giving one state notice. Those are the cases that I've seen of failure to register on a federal level. It usually requires travel across state lines.
But one of your points is that the legislature didn't put in the word direct
No, it did
into
not.
the statute. They could have, but they didn't. And
They could
your
have.
view is that, that the consequence doesn't have to be a direct result of the conviction because they didn't use the word direct.
They did not choose to use the word direct. However, I would still argue, even if they did use the word direct, as Sylvester makes clear, sex offender registration is virtually a certainty, a practical
so
certainty.
I know if we accept your argument in the STP context, would it have to be just for the indexed offense? Or would it be for an offense that also helped prove that the person was a sexually dangerous person?
Well, the statute says as a result of,
Right.
which generally would require that but for. So if an individual had 2 sex offense convictions that would trigger SDP commitment, it is likely not but for the one conviction because there are multiple convictions. And I did point out in the brief that this is Mr. Johnson's only. If he had 3, 4, or 5 sex offense convictions, then his requirement to register would not be.
May I ask you a question about the brief? In your appendix, I see that it says that the judgment was denied based on the reasons in the Commonwealth's memorandum, and I have your memo. Is the Commonwealth's memorandum in the appendix anywhere?
The Commonwealth's memorandum is in the appendix to the Commonwealth's brief.
Commonwealth's brief,
The
okay.
Commonwealth made 2 arguments. Essentially, one was that there's no jurisdiction because Mr. Johnson is not in prison or on probation or parole, but also he filed this motion, a similar motion, pro se in 2014. The motion was denied without a hearing based on the argument that he was.
I don't mean to get hung up in the appellate rules. I was just, is it supposed to be in your brief, or is it supposed to be there because it's the basis of the judge's decision? It's not relevant right now, but I'm just curious if you know.
I provided it, I was asked to provide it by a clerk of this court, and I sent it to the court
Thanks.
by email.
And there's no waiver, so there's no appeal. So the original one went to Judge Lemire, right? The pro se one went to Judge, he denied it,
Correct.
and then you filed the second one?
I was assigned by CPCS in 2018 as part of their Innocence Project, and I reviewed the case and the motion. I filed the counseled motion in 2018.
Was it a
But
motion for reconsideration, or was it a second motion?
there had been too much time. It had been 4 years since the motion
Okay,
was denied, so it was far too long to relitigate the motion, the pro se motion that had been denied, so my only
But
alternative.
we allow people to file serial 278A motions, right?
I've noticed that most of the cases that have reached this court have been on successive, not first 278A motions. I've noticed that in many cases, pro se litigants who file post-conviction motions are having their motions denied without having them first referred to CPCS for appointment of counsel. So we try to encourage the clerks, especially in the Superior Court, to try to reach out to CPCS before.
Maybe the problem is, as Justice Budd in Commonwealth versus Williams recently pointed out, that this is an issue of whether or not there's standing to have the Commonwealth respond and have a hearing. And maybe when you see the motion, somebody saying, oh, gosh, well, that means there's a request for testing. It's a request to have a hearing as to whether or not there's going to be testing. And that's, if I understand it, you're at the stage where you're saying that you have standing to have a hearing to see if there has to be testing.
That is
right?
correct. We're at the very beginning of we haven't had the hearing to summons in the evidence officer to determine.
Yeah, we don't know if this rape kit exists.
Not in the record, we don't.
Okay. You don't have to tell us.
I don't think we would be here if the rape kit didn't exist, but it's not in the record. That would come at a subsequent hearing if this
Well,
if this appeal
I
were allowed.
really should wait until the Commonwealth speaks to ask this question, but why doesn't the Commonwealth want to check the rape kit to make sure they can identify the guilty person? Why aren't they racing faster than you are? I mean,
Well-
if there's a rape kit, then, and I have no view, obviously, as to whether he's guilty or not guilty. I don't know anything about it, but it seems like it would be a good idea if he pled to time served, if he's not guilty, not only, most importantly, to get the conviction vacated, but also maybe try and find the person who committed the rape. I mean, why aren't they racing fast? You're the wrong person to ask the question, but it seems to me they'd be racing faster than you are to have the rape, well, it's not supposed to be called the rape kit, the evidence collection kit.
I assume they think they have the right person.
I assume so.
I would have to assume they firmly believe
Don't
they
gotta
have the
find
right
guilty.
person.
Just
I don't know.
retest
I
everything.
figured I'd
You could just
like
retest
to
all the
know.
evidence everywhere, ever.
I think it costs money too, so
Yeah.
that might be a consideration the Commonwealth has.
Yeah, I know, but this is a situation where, and you pointed out in your brief, I think, pretty well, this is a situation where the defendant had an opportunity to plead guilty to time served. It's not that's the background of the plea.
1 year for what is presumably a forcible rape is a deal nobody could take a pass on. Perhaps now with sex offender registration consequences, he may have thought differently, but back then, he could just walk out with no consequences. He would have been a fool not to take the offer.
In the universe of liberty, you're teasing out for me, and it's very, very helpful, because I'm trying to figure out what that clause means, which is really the centerpiece of this case. So you've identified the SDP context, perhaps some subject to deportation and sex offender registration, right?
As an analogy, I looked to the cases that deal with what do attorneys have to advise their clients about. Those are severe consequences. And Padilla mentions deportation. Sylvester kind of touches on SDP and sex offender
We're
consequences.
looking at collateral consequences that have a deprivation of liberty. That's where you looked?
That's where I looked, to those cases, Padilla and Sylvester.
Now, knowing Justice Lenk as well as I do, if she were here, she would be saying, I believe, we were among the last to enact this type of a statute.
Correct.
Am I correct that that the legislature would have looked to other states' models before they drafted what they drafted?
Presumably, they would have, yes.
And do other states have similar language?
Other states vary. Some list the crimes for which are qualifying. Some list the type of offender that are qualifying. Some are not very specific at all and allow anybody who's been convicted of an offense.
And is there any legislative history as to why the legislature chose this language, given all the variants?
I looked at the House and Senate reports and the initial bills, and I could not find the reasoning why this particular language was selected. However, it did change. Originally, it was in custody or otherwise restrained, which the Commonwealth could make a terrific argument that otherwise restrained therefore means probation or parole. But then they added probation and parole and kept otherwise restrained. So that must mean something.
Some states have specifically sex offender registration. The
Yes.
states that the Commonwealth put in its brief
Yes.
has those, and we chose not to.
We chose not to. We chose to simply say otherwise restrained and to leave it to this court to determine what that means. If there are no further questions, thank you.
Ms. Saran?
May it please the court, my name is Donna Marie Heron, Assistant District Attorney representing the Commonwealth. I can see where this court's going, but the Commonwealth's argument is that the motion judge properly denied,
Don't be so sure.
I'm pretty sure, denied the defendant's second motion for post-conviction.
You must be a good poker player, but let me ask you something.
I feel that, I mean,
But let me
it
ask
is what it
something.
is. After Putnam and Williams came down, I can see where the train is heading, but
But
let's
let-
go.
but
You may know where the train's heading. I don't know where it's going yet.
let me ask you something. What else could, so we have incarceration.
Yes.
We have probation. We have parole. Then the language says, or otherwise. what else is there in the world other than those three things that it would cover?
Well, I guess the Commonwealth's concern is where do we end? And for instance, do we end where, say, Mr. Johnson, instead of failing to register as a sex offender in Florida, committed another rape in Florida, and then was charged as a subsequent offense and got a bigger sentence? Then he comes back to Massachusetts and asks, I want to retest it because I'm now facing a
But
longer sentence.
In this case, it's almost easier because he happens to be behind bars.
20
now-
years later,
Well,
yes.
but he happens to be behind bars in Mississippi in federal court, right?
So that's the Commonwealth's position, as it is, that he is in prison for that conviction, not for this conviction. That is the Commonwealth's position up here. That's what was argued below to Judge Lemire to begin with, and then to Judge Kenton-Walker.
You're arguing he's in jail as a result of his failure to
Register, which is a separate conviction. That is the Commonwealth's argument that was first made in 2014, and Judge Lemire denied it. He raises the exact same claim. The motion is basically the exact same motion 4 years later, and the Commonwealth responded with collateral, was a stop from re-arguing, and the same argument it made below in 2014, that he's in jail as a result of the Florida conviction and not as a result of this conviction. And and as I argue in my brief, as pointed out, if the legislative wanted to have sex offender, Kentucky does, Ohio does, they specifically have registration in there. Other states such as Hawaii.
Let me just ask you, I get that, but just in terms of Justice Gaziano's question, what could this possibly mean, or otherwise restrained? Because I understand your point of view that, where does this end, but isn't that a question for the legislature to fix because it's there?
It is there, and I don't have a good answer to that question. I don't know what they mean by that, to be honest with you. The Commonwealth's concern is that they put some parameters on here, and if they wanted anyone at any time to file this motion, like Hawaii did and Georgia did, they would have specifically put that in the statute. They did not.
The legislative history is tough for you because they did have that phrase, then they added in probation, parole, and kept the otherwise.
They did. I just think it's tied to direct result of this conviction, but
So it would have to be redundant to probation, parole.
probation, parole, or anything directly tied to this conviction here,
I'm
that's
just trying
not
to
a,
think of what else could there be other than this? But
Do we know, does anyone else use the word otherwise restrained?
I did a 50 states search. I did not find any other states. It's quite interesting what the other states have. Some have it directly tied to certain convictions, like Kansas, I believe,
language-
it's just first-degree murder and rape. Others have it at any time. Others have a statute of limitations as a sort. They have 3 years. Some have 5 years to which they can file this motion, and then the defendant is deemed waived. And in one state, which I interestingly found, said the defendant can file it at any time, but his DNA will go into the database, and if it hits on another crime, he waives the statute of limitation for that crime, which I thought was quite
Okay, so where does?
severe.
So we have no idea where this language came from? When they drafted this statute, was there a bunch of material they filed with the statute? Or was this a BBA? I can't remember, this was a BBA initiative?
Yes.
I know there's a reference to a law review article by Greg Massing and somebody else. Was he on that committee?
I'm not, I don't have the, I don't know, I'm
Do we
sorry.
have, do we have a pile? Did you read the material submitted by the BBA group?
I did not, Your Honor.
Okay, so we actually don't have a full view of what the legislative history says on this yet,
I don't believe we do, no, Your Honor.
because that might be informative, right? Should we go looking for that?
You can if you,
If I want to.
if you want
If
to,
the
Your
train
Honor,
hasn't-
after.
If the train hasn't already tracked where it's going. is
After
that what you're
Williams
saying?
and Putnam came down, I just,
Yeah, okay, all right.
Assume the
But so you
inevitable.
haven't read that report, and this law review article by Massing, does it just address this issue, or we know?
I haven't read it, Your Honor, I'm sorry, I can't answer that question.
So you don't know whether the proposal of the BBA may have contained this language or not, you don't know.
I don't know, Your Honor, I'm sorry.
So, but arguably, we'd have to go back to see, to go to the very beginning of it, because I know there was a major initiative. And I look over your shoulder and I see somebody from the BBA right there, so, which perhaps is not unrelated to this case being heard today. Okay, so, but in terms of your concern, I understand it, but is it your view that if Mr. Johnson had brought this matter before he had been convicted, he would be better off? Because then he would not have been in custody because he violated the law?
I think he would have been better off, yes, because it's Commonwealth's argument, he's in jail in Florida because he violated, well, federal law.
Isn't that sort of a strange result that yes, it's okay, he would have the authority to challenge the validity of his conviction if he were merely somebody who had been classified as sex offender, but then he loses the ability to challenge the underlying sex conviction if he's now actually jailed for violating his obligations as a sex offender.
The Commonwealth's argument, I think, would be the same, because as I said, looking to the other state statutes, they could have specifically put in registration as a sex offender as one of the qualifications to be entitled to the statute. But the Commonwealth's argument raised below was that it is different, because he waited 20 years to file this.
You would argue that his liberty, if he brought this before he was incarcerated, his liberty was not restrained, so
Yes.
he would not have the ability to
Yes.
bring it. So you're thinking he doesn't have the ability anyway?
The Commonwealth's argument, I think, would remain the same. I think our argument's much stronger, the fact that he's, in the Commonwealth's view, committed a new crime and is incarcerated on that new crime.
But I can't remember if it's the BBA brief or the CPCS brief, but there's a point in there, putting aside the fact that he's convicted and how that, and in prison right now, evidently in Mississippi, and whether or not that's a consequence. One of the amici made the point of, well, see how huge this liberty interest is? It's such a considerable liberty interest to have to register that you could end up in prison 20 years later as a result of it. And they make the point to show how significant a liberty interest is of having to register.
The Commonwealth's argument back would be if the legislative intended that, like the other states I cited, it would have specifically put that in the statute.
No, but that's a good point about Hawaii and about Ohio and Kentucky, but we do have to do something. We can't just leave hanging out there with no meaning whose liberty has otherwise been restrained.
And this court can say that that qualifies, and then the Commonwealth will, then the case will proceed to Section 3 and then to presumably Section 7.
In terms of the issue of whether there's a liberty interest, what if the legislature had permitted the classification of individuals as sex offenders without giving them a right to a hearing? Would you agree there would be a constitutional problem in doing that?
Can you repeat your question? I don't quite understand it.
What if the legislature had permitted there to be classification of a sex offender with the obligations that it would mean to be classified level 1, level 2, level 3, but did not require there to be any hearing or any opportunity of the offender to be heard? Would you see there to be a constitutional problem if that were to happen?
Yeah, this court has clearly ruled that they have a constitutional right to have a hearing for registry as a sex offender. And the Commonwealth's not disputing that that's a restraint on your liberty. The Commonwealth's just arguing under 278A, they specifically tied it to conviction under that charge. And the Commonwealth's argument, again, is that the defendant is not in prison on facing a consequence of this. He's facing a consequence of his own choosing, which is violating a federal statute.
Okay, so you're not, you conceding that indeed classification as a sex offender is a restraint on
Yes,
one's
it's
liberty?
a type of restraining liberty, of
Okay,
course,
so you're
Your
not
Honor.
challenging that?
No, I'm not, Your Honor.
Even level 1?
It's very minor, but I guess one can make an argument that it is a restraint on your liberty. But as pointed out, there's not in this record of what Mr. Johnson, what level he is. We don't know under exactly the elements that he was found guilty in Mississippi and then in Florida, because I think initially he was charged in Mississippi. I have issues with III sometimes, so I'm hoping I'm reading it right, but he was charged in Mississippi in 2012, got out, went to Florida, and then was picked up there, and that's when he got sentenced to the 10 years. That's how I read the III.
Going back to the rhetorical question Justice Lowy asked of the wrong person, I look at this and I say, golly, isn't this precisely the type of case that should give us pause? You have a very serious, forcible, aggravated rape, allegedly of a black man against a white woman, and the Commonwealth is prepared to agree ultimately to 1 year time served and to drop the aggravated rape and charge him only with indecent A and B, even though I gather there's no dispute that there was penetration. And now he's saying you got the wrong guy, and the Commonwealth must have thought that there was serious issues with the case in order to agree to that. If you're right, somebody like that would have no remedy, because he got time served, so he's no longer incarcerated, not on parole or probation. He would have no ability, if he were to say, I just can't throw the dice and go to trial, or stay in jail to go to trial, to be able to get rid of that conviction.
I guess the Commonwealth's first response would be there's numerous reasons why Commonwealth amends or agrees to plead out to a lesser included. A lot include the victim's credibility or issues with the victim, or there's other issues in the case. The Commonwealth would never proceed with a trial or a plea if it believed the defendant was innocent. There's numerous other reasons other than the defendant being innocent as to why they chose to go that way. And the Commonwealth looks out for the victims, which I know doesn't matter in the statute, but looks out for the victim's interests in having finality in judgments and not having to revisit something 20 years later to inform them that the defendant, for whatever reason, is now facing, after being out for 20 years, he was out free in the public, which he could have filed this, but chose not to, and it wasn't until 20 years later that he picks up another charge that he decides to file this 278A motion. So the Commonwealth's, I just don't think there is a concern there, given the fact pattern of this case.
But I'm not suggesting in any way anything but good faith of the prosecutor back those years ago. But the victim who had her soul destroyed at least on some level by being raped like this, I would think would be the biggest advocate of making sure that the right person was caught and punished. I mean, the number one concern, for reasons too obvious to state, is to make sure if this person's innocent that he not have this conviction and whatever else flows from 278. But there's also the other concern, and it's a real concern about identifying who did this, if it wasn't him. I'm not saying it wasn't him. I'm not in any way suggesting that. But take Chief Justice Gantz's overall point about the legislation. The advocates of the legislation had 2 points. The most important one being to identify innocent people who were wrongly convicted, but also identify people who were guilty who didn't have to pay the consequences of their what here was a vicious rape. It's the same point Chief Justice Gantz is saying. I mean, this is a concerning situation, and he may very well be guilty, but this is a concerning situation, and we're deciding whether he is standing to litigate it, that's all.
I appreciate this court's concern. The Commonwealth's position, though, remains the same, but I appreciate this court's concern.
But the problem with your position is that if you're right, a person in that position has no remedy, has no ability to get the testing.
Well, no, he could have tried, after he pled guilty, he could have then filed the motion for 278 to try to prove his innocence when he was facing a direct consequence of it. But he waits 20 years later, and then...
He was no longer in jail. He was no longer in jail. He was not on probation. He was not on parole.
No, the statute wasn't enacted to 2012.
Right.
And he wasn't
He would have
picked
to
up.
file a Rule 30 motion.
Yes, he, at the time, could have filed the Rule 30, which you can file at any time. I mean, clearly, but it didn't seem to bother him until he faced a real...
But put him aside. Let's assume it happens today. Same case. Time served. He's no longer in prison or in the house. He's not on parole. He's not on probation. You would say no remedy, no ability to have a testing of the kit.
Yes, because I wouldn't see why a defendant would plead guilty. Well,
If you're offered time served
at
as
this,
opposed to...
I mean, I can appreciate back in '94 that the DNA testing is involved much more than that. But in this day and age, I cannot see a defendant pleading guilty to a crime for which DNA testing is readily available now and readily done pretty much on every case there is, to plead guilty blindly and not, so bring it to today. I don't see a situation where that would happen, to be quite honest with you.
Well, that's a fair point, but the problem is that, I mean, good point. But the problem is, according to the defendant's brief, is that he didn't know that there was an evidence collection kit when he pled guilty. So, I mean, I take your
Yes.
point,
Can
but he
I
didn't
shift
know.
back to the case for a second, as opposed to what you guys do next? I just read the BBA report, which is attached to one of the amicus briefs. The language appears, they drafted this statute, it looks like. That one of the people on the panel then wrote a law review article that actually says, it may apply to sex registers, it may not. What do we do with that? We actually know who drafted this, and they weren't sure with that issue. We do anything with that, or we just sort of say, whoops?
Well, I guess they're leaving it for this court to define whether it applies or doesn't apply.
So we actually know the legislative history, we know that the issue wasn't contemplated possibly by the drafters, but they punt to us, okay.
I guess they did punt to you.
Okay.
All right, thank you.
We'll take our morning break.